afternoon. Hope you had a good lunch. Welcome to the session on excessive pricing on pharmaceutical markets at the OECD's Open Day. We have some very knowledgeable and expert speakers with us, so I will strive to be as short as possible. I would just like to frame the session and introduce the speakers. Despite undeniable advances, policymakers and other stakeholders have become increasingly concerned about the outputs of the pharmaceutical system. The price of many novel drugs make affordable access to them very difficult. The cost and pricing structure of the pharmaceutical market are often opaque, and questions about the degree of innovation and value are increasingly being raised regarding new treatments. Given these concerns and the political, economic, and individual implications of access to pharmaceuticals, we at the OECD have been looking at the sector in recent years, both at the Competition Committee and in other parts of the House. From a competition perspective, one can say that the particular challenges to the pharmaceutical market have two main sources: the market structure and the dense regulatory network that affects the market. These two are connected. After all, the extensive regulation is a consequence of the myriad ways in which the pharmaceutical market departs from our models of perfect competition. Of course, this is not the case for all medicines. One needs only to think of aspirin, for example. But for many medicines, there is a challenge that arises from the lack of alignment of incentives of people who consume, the people who choose, and the people who pay for medicines. So in most markets, individual consumers combine these three dimensions, which allows price to influence consumer choice and hence demand. Not so as regards many pharmaceutical products. For a large number of medicines, and particularly essential medicines which are under patent, patients may not be responsible for paying for them. The principle that third-party payers, namely governments and health insurance, should cover a number of these medicines is well established. In addition to that, doctors who prescribe and often choose these medicines are often not influenced by their price. And lastly, consumers and patients may not be particularly price sensitive, either because the medicines are indeed necessary for their health or because they do not pay part of the costs. So given this, it is common for pharmaceutical markets to be densely regulated. This concerns their efficacy, their safety, but also, particularly in the context of regulated, prescribed drugs, it is also the case that price is often regulated. This is not often the case, so much the case with generics. It is one of the main axioms of competition law in this area and regulation that we expect generic entry to lower prices. So whereas there's still regulation, we expect competition to lower pricing and let it run its course. Now, this axiom has been challenged recently. And it has challenged mainly in terms of, we have seen high prices for generics, and particularly started to see price spikes for generics. And a consequence of that, and the reason we are here today, is that a number of competition agencies saw the need to step into the fold and address that issue instead of the regulators. So to help us address this today, the session will be structured slightly different from the previous ones. We will have a more structured session where we will go from a description of the market to individual cases to the challenges of bringing those cases and a discussion about whether the pros and cons of bringing such cases in the first place. To help us with this, we first have Valérie Paris from the OECD Health Division. She has been with us since 2005 and has worked on this area for a long time. We also then have Andrea Pezzoli, who's the Director General for Competition from the Italian Competition Authority. The Italian Competition Authority, as we'll see, has brought one of the main cases in this area, and Andrea will help us introduce us to the type of cases. We will then have John Davies. John Davies is presently a Complex Lexicon. Before that, he was at the UK Competition and Markets Authority, and after that, he was the head of the Competition Division at the OECD for a number of years. And John will discuss the main implications of, and challenges of bringing these cases. After which, we will have Philip Marsden, former director, chair of the Department of Decisions and Inquiry at the CMA, now a director of part of the team for enforcement at the Bank of England, one of the financial regulators, and Ofgem, the energy regulator, and also a visiting professor at the Collège d'Europe. So without further ado, Valérie?
Thank you very much for the opportunity to speak today. My presentation will appear, I guess. So let me first say a few words of introduction about the specificities of pharmaceutical markets in complement to what Pedro already said. In most OECD countries, the whole population obtains coverage through government or compulsory health insurance schemes, and these schemes finance more than half of retail pharmaceutical expenditure. As you will be able to see on the slide, I don't know if it's, oh sorry, the blue part of these bars is public or compulsory health insurance financing of pharmaceutical expenditure. And the share of expenditure for drug dispensed in hospitals would be even higher. This makes this and the other characteristics already mentioned by Pedro made the pharmaceutical market very specific, and it has pushed most OECD countries, but not all, to regulate the prices of pharmaceuticals in one way or another. When paying for pharmaceuticals, policymakers seek to achieve a balance between two objectives. On one side, they need to pay enough to provide incentives for companies and to provide an attractive return in order to incentivize further investment in R&D. But on the other side, they don't want to pay too much, too high prices to ensure, to guarantee access to medicines and also to make sure they get value or the maximum health benefits from the money they spend on medicines. This chart, proposed by the Danish Drug Procurement Agency, illustrates price levels along the life cycle of a medicine. As you all know, the price exceeds the marginal cost of production in the first 10 to 15 years after market entry, thanks to IPRs and other forms of market exclusivity, and then it decreases when the product faces generic competition. As a general, so not systematic rule, OECD countries tend to regulate prices in the first period and to rely more on competition in the second period. Price sometimes drop drastically, as you can see on this chart, which can lead to supplier exit from the market, supply risks, and de facto monopolies and price increases, as you know. As mentioned just before, oops, sorry, I went too far. Most OECD countries regulate directly or indirectly the prices of medicines with market exclusivity, especially when these medicines are covered and when they are dispensed outside hospitals. To do so, they use different approach, but they most often rely on health technology assessment, either to assess the cost effectiveness of the new product and determine whether it should be covered or not and at what price, or they do a clinical assessment of the drug and the added therapeutic value of the new product is used in the price negotiation together with other criteria such as the prices observed in other countries. In many countries, prices after market entry are constrained. Price increases, after market entry is constrained or even prohibited. As a result, prices of existing medicines tend to decrease or to remain stable over time before patent expiry. This is illustrated on this chart, which represents price indexes for biologic disease-modifying anti-rheumatic agents in several countries, including Canada, France, Germany, and the UK between 2010 and 2015. When you see that prices have remained stable or declined, except for the US, where the list price has increased by 60% over the period. There might be an artifact also, since list prices are increasingly disconnected from actual prices paid, especially in the United States with the proliferation of confidential discounts. Such price indexes, by definition, do not take into account increases in launch prices of new medicines. Actually, drug prices at market launch have increased over time, which is partly explicable by the increase in R&D costs, but not only. In some therapeutic areas, like in medicines used to treat rare diseases or in cancer, which now represent 30% of all drugs approved, prices have increased sharply. From the industry side, these medicines often target small population, and companies need to earn revenues, even with small volumes of sales. From the payer side, the willingness to pay, sometimes highly influenced by public pressure, has proved to be higher for these drugs also, because they serve unmet medical needs and very severe diseases. Also, there is no agreement on whether this trend will compromise the sustainability of health systems, whatever it means. Policymakers are increasingly worried, concerned by the fact that they are paying high prices for clinical benefits which are not always commensurate. This chart shows the evolution of the launch prices of cancer drugs per year of life gained over the 20 past years. On the left, you can see that in the US, the average price per life year gained has been multiplied by 4, and in France, where starting prices were much lower, this price has been multiplied by 9. Further analysis in our report, published in 2018, shows that the R&D-based pharmaceutical industry has remained profitable over the past 15 years. It also suggests that investors earn more than required by the specific risk of the industry. And this chart shows that profitability is significantly higher than in other R&D intensive sectors, such as IT or aerospace and defense, and has expected higher than in the generic industry. Now let's come back to off-patent markets, which are the subject of this session. Well, it doesn't seem, oh, sorry. Sorry. It doesn't work very well. I need to, no, okay. We don't have data about the respective market shares of on-patent and off-patent drugs, but we can see here the generic market shares in volume, the dark blue bars, and in value, the light blue bars, in a range of OECD countries. On the left, you have countries like the US, New Zealand, Germany, and the UK, with very dynamic generic markets, and on the right, you have countries like France, Switzerland, Greece, and Italy, where the uptake of generics is very low. Focusing on off-patent markets, in the report we published in 2018, we highlighted a number of worrying trends. As you know, a few cases of sharp price increases have received substantial media attention. This is the case of the Mylan's EpiPens, whose price increased by 500% over 10 years, and of the Turing HIV medicine Daraprim, whose price increased by 5,000% overnight. Such high price increase have also been observed in other countries, such as the UK, Italy, Australia, and some of these cases have been brought to competition authorities, as you will hear later. The common element in all these cases was that the supplier was in a monopoly position. And the big question for us is to understand whether these cases are and will remain exceptions, with little impact on generic markets, or whether they reflect more systematic risks in off-patent markets. Recent studies actually have shown, have noted unexpected price trends in off-patent markets. We quoted several of them, like in Canada, the prices of single-source non-patented drugs have increased on average by 18% between 2010 and 16. In the United Kingdom, the average price of generics increased by 14% in 2015, and in the US, 1 in 5 generics marketed between 2010 and 15 experienced extraordinary price increases, higher than 100%, which moderated the price erosion of established generics. So the impact is not anecdotal. A recent study of trends in US generic markets published by the NBER. So the trend between 2004 and 2016 showed that 40% of generic molecules were supplied by a single manufacturer and 20% by 2 or 3 manufacturers. The number of generic manufacturers has decreased, and generic prices have risen faster than inflation, especially in those market segments with few competitors. So what are the solutions to address these issues? We highlighted a few policy options. The first set of options aims to facilitate market entry of generic products after loss of exclusivity of originators. It consists, for instance, in allowing generic manufacturers to complete regulatory requirements prior to loss of exclusivity, which already happens in some countries. Also in creating readily accessible and searchable databases to compile patents and exclusivity status of originator medicine, as done by the Orange Book, the FDA Orange Book, but this does not exist in all OECD countries. And the FDA also committed to identify areas where generic competition is limited to give priority to assessment of generics in these specific areas. The second set of options aims to encourage healthy, what we call healthy price competition. For instance, through encouraging competitive mechanisms in drug procurement, such as tendering, but in a way to avoid single supplier contracts with appropriate safeguards to secure supply and preserve long-term competition. And when generic competition, which happens in many countries actually, when generic competition for market shares takes the form of discounting in the supply chain, then payers should impose price disclosure to make sure discounts are finally passed on to public payers and consumers. Finally, there are many ways to encourage further the uptake of generics and biosimilars through steering the behaviors of all stakeholders in the system. This means, for instance, allowing or even mandating prescribing by international non-proprietary name, INN, allowing substitution for generics, use prescribing software that highlight price differences or even select the cheapest alternative by default, to introduce financial incentives for pharmacists to dispense and for patients to accept generic and biosimilar products, educate professionals and patients through information campaign, but also implement a system perhaps to monitor market dynamics and allow purchasers to report any sharp price increase. And when the number of competitors becomes low, perhaps it's time for the regulator to start negotiating price increases with generic competitors. And finally, enforcement of competition and antitrust laws could also provide a recourse for countries, but we understood that these were quite costly and difficult to conduct, so this was not the first option. The idea is more to prevent competition issues rather than cure them. Thank you very much for your attention.
Thank you, Valérie, for that very comprehensive and complete discussion of the market. Andrea will now introduce us to the intervention that competition agencies have started to pursue in this area, particularly by pursuing exploitative excessive pricing cases.
Thank you so much. My task is to provide a brief presentation, let's say just a flavor of given the time constraint of a recent decision of the Italian Competition Authority concerning excessive pricing in pharma. But before starting my presentation, I would like to thank the OECD Competition Division for this kind invitation. Let's say, okay. Allora, at this point of the of the panel, I think we can have just a quick look to the first slides, which summarizes the necessary conditions which may allow a very exceptional antitrust intervention on these issues. Let's say, I mean, the lack of regulation or a weak regulator or just a negotiator, we'll see. Clear-cut dominance, sometimes a super dominance where we deal with a legal dominant player. And afterwards, the two difficult steps of the analysis. The first step concerning the excessiveness, and the second step concerning the fairness. So we'll see that, I mean, there are some ingredients for these tests, but we'll deal with them afterwards. The Italian Competition Authority, in line with other European competition authorities, has taken in the past very few decisions of infringement on excessive pricing. I mean, in 28 years, I mean, just 3 decisions concerning excessive pricing. One concerning airlines, where the benchmarks were both the pricing behavior of a non-dominant competitor and the cost of an efficient, a so-called efficient player, and 2 on airport handling services, where the benchmark was directly provided by the sectorial regulator. I mean, just for history, I mean, the first one was concluded with a clearance, with a non-violation, because there was no sufficient evidence. So the Aspen case was the very first application of 102A in the pharmaceutical sector by our authority. And I mean, the case concerned a portfolio of cancer drugs that Aspen had bought from a different company, GSK, in 2009. And the authority began its investigation in 2014 after a consumer association claimed that the national health system was experiencing shortages in the provision of the cancer drugs. So that was the very reason of the start of the proceedings. The shortages ended in March 2014, when Aspen, at the end of a negotiation with the pharma regulator, with the pharma agency, AIFA in Italian, had obtained substantial price increases for those drugs. I mean, the price increases ranged between 300 and 1,500. And the prices charged by Aspen were deemed excessive after a careful analysis performed using several tests, and in my view, substantially consistent with the analytical framework proposed by the European courts. I mean, in our assessment, since this morning, I mean, speaking of pharmaceutical, and not only pharmaceutical, I mean, we dealt with the possible conflict between static and dynamic competition. I mean, I have to stress that in our assessment, we were extremely cautious because of the risk of discouraging innovation in markets in which innovation, like in the pharmaceutical markets, may play an extremely important role. I mean, just a quick look because to the Italian regulatory framework, which can be helpful for a better understanding of the case. And particularly, I mean, we have to stress that the Italian national health system grants total reimbursement for drugs that are deemed essential for the patients. We call it Class A. The price of these drugs is defined through a negotiation process between the pharmaceutical companies and the pharma agency. But if there is no agreement with the pharmaceutical company, the drugs would be automatically moved in the so-called Class C on charge of the patients. In 2013, Aspen submitted to the agency an initial request for reclassification, And in March 2014, the negotiation ended with the agency's approval of a new A-class prices for Cosmos drugs, accepting the prices increase submitted by Aspen. The outcome, and this is quite important point, of the negotiation was seriously influenced by the threat advanced by Aspen of leaving the Italian market if the regulator didn't accept the price increases. So at the end of the story, the important ingredient is that our pharma agency, rather than a proper regulator, is just a negotiator and has no power to impose prices in case of disagreement. I mean, we may completely skip the slide concerning the market definition because, I mean, there were so many elements to discuss within the case, but, I mean, I can say for sure that market definition was not a real issue during the proceedings. Much more interesting may be a few brief comments on the assessment of dominance, because, I mean, in this case, we observe a lack of effective competition. Aspen, in fact, was the only supplier in each of the relevant markets. Lack of potential competition, no patent barriers, but lack of incentives to entry. In fact, the scarce sales volume at the new prices reduced the incentives to enter in the market. And in fact, no generics entered in the market. But even more important, I mean, we observed an asymmetric bilateral monopoly where the supplier has higher bargaining power, I mean, and the pharma agency has no power to impose price, needs to keep the drugs in Italy as a drug reimbursed by the national health system, and without the agreement, the drugs would be automatically included in the class on charge of the patients. And on top of that, the demand of the final consumers for life-saving drugs is clearly and fully inelastic. So the conduct is a typical exploitative conduct. So the infringement of 102A consists in the imposition of excessive and unfair prices through the adoption of a quite aggressive negotiating strategy. In fact, Aspen threatened discontinuing the supply of the drugs on the Italian market if the increases were not approved. The Italian Competition Authority adopted a two-step analysis, the traditional two-step analysis. First, the assessment of the excessiveness, and second, we consider the case-specific elements to evaluate the unfairness of the prices. So our authority reinforced its analysis by using two different measures of the excess of prices. So, I mean, answering the request of a combination of different methods, and this is in line with European case law, which favors the application of more than one method of analysis in order to reinforce conclusions and to avoid false positive. So the first method, I have not time to go deeply into it, but anyway, was the traditional gross margin method. The resulting gross margin in percentage of sales was compared to the total indirect costs in percentage of sales to conclude that prices before the increase already granted a margin in line with Aspen average. Therefore, price increase percentage ranging between 300 and 1,500 of initial prices conducted to an unreasonable excess of prices on the so-called economic value, whatever it means. I mean, I'm an economist, I mean, so the economic value is a concept that is not very easy to deal with. But anyway, the second method tried to reinforce the analysis. There was the cost-plus method, and the analysis allowed to conclude that prices applied by Aspen generate excess in percentage of cost-plus ranging from 100 to almost 400, and these percentages are well above those which have been considered abusive in previous cases. So the excess ranges from around 100 to almost 400, depending on the assumptions on the rate of return granted in the calculation. So 13%, which was a quite generous rate of return which the Italian Competition Authority allowed for the assessment. We had also a supplementary benchmarking, so an intertemporal comparison of prices, and again there were increases between 300 and 105,000%, which were considered not necessary because they didn't generate losses or very low margins, and previous prices already covered direct costs. So actual prices, using the wording that the Advocate General Val used in its opinion, were significantly and persistently above the benchmark prices. The specific, and I would say the exceptional features of the case made the assessment of the unfairness, let's say, relatively easier than usual. Do not forget that the provision of justification, it's up to the defendant. But anyway, in this case, we observed that there was absence of any economic justifications for such an increase in prices, because there were no increases in production or distribution costs documented by Aspen, no need to recover innovation investments, and absence of any non-cost related factor leading to an improvement in quality or in the level of services. And at the end, and also on top of that, we have to consider the specific nature of the drugs, so life-saving drugs, and the characteristics of Aspen's strategy, which was not based on innovation efforts or on R&D expenditure. On top of that, we had also to consider the aggressive strategy adopted by Aspen that I already tried to explain, but it played a quite important role in the understanding of the case. Before concluding, it is worth spending few words on the injunction and on the compliance proceeding. In September 2016, finally, we concluded the case, and there was a cease and desist order. The decision didn't tell Aspen what prices to set and how to set them, as tradition in these peculiar cases. Aspen request for interim measures was rejected in February 2017, and Aspen appeal of final decision was rejected in July 2017, but the story didn't end here. In March 2017, the Italian Competition Authority was forced to open the non-compliance proceeding, and a tiring negotiation process between the agency and Aspen started again till in March 2018, the Italian Competition Authority sent a statement of objection to Aspen, alleging a dilatory strategy by refusing to provide relevant information. After that, finally, a sort of happy ending. In April 2018, Aspen finally submitted all the relevant information and reached an agreement with the agency. You can look at the table. There was a significant reduction in prices up to 80%, 80-something percent. Estimated public savings roughly 8 million per year on the basis of the public prices, net of legal discounts and selective reductions. This is the best way to present a case like that, and let me conclude with some few concluding remarks. I can say that whilst opinion provides a useful legal framework for the assessment, the specific, I would say the exceptional characteristics of the Aspen case fit the criteria suggested by Val, even those more complex concerning the fairness test. As an economist, I might say that legal tests reveal to be useful, but little help has been provided by the economic theory in the assessment of excessive pricing. I would also say that the practical results reached by the Italian competition authorities' intervention could be considered quite successful. But above all, I could also add that in this perspective, the Aspen case confirms that competition authorities' intervention on excessive prices should be exceptional, but cannot be excluded, especially if we believe, as Fred the Giant said it this morning, that without possibly abandoning the consumer welfare standard, competition authorities should not ignore the increasing requests of fairness coming from the society. Finally, and that is possibly the new episode of a long saga, I would also say that there might be scope for the advocacy activity of the Italian Competition Authority, because the case emphasized the regulatory gap and the need for empowerment of the pharma agency, which is the most straightforward way to deal with excessive pricing. And I have to conclude saying that the Italian Competition Authority is monitoring, hopefully positively, the process. Thank you.
Thank you very much, Andrea. I would now ask John to give us a presentation on the main challenges of bringing these cases, particularly in this sector.
Thank you, Pedro. While I'm waiting for the slides to come up, thanks to OECD for inviting me, and congratulations on this first Competition Open Day. It's a great success. The room is still full. It's the afternoon. That's impressive. I wish I'd thought of it when I was still here. Let me also declare a few interests. Together with some colleagues, I worked a little bit on behalf of Aspen on the first appeal in the Italian case we just heard about, also worked much more for Aspen in the subsequent investigation by the European Union into essentially the same sorts of issues elsewhere in Europe. And I'm working on one case that is currently in front of the CMA in the United Kingdom, and some of my colleagues are working on other excessive pricing pharmaceutical cases in the United Kingdom. But none of us have worked, as far as I know, on the phenytoin case, which is the only one which has come to a decision in the United Kingdom, which Philip chaired and will doubtless talk about. But I have written an article together with my colleague Jorge Pedro, which is published in a book edited by Frederick Genie, so it's a very small world. And because of that, I'm going to use examples from time to time in my talk from the phenytoin case, really just because it's the only one I'm allowed to talk about. Certainly not because it's a case that we regard as particularly bad or anything like that. Okay, challenges. Yes, I'm going to talk a bit about challenges. I was also asked to talk about the economics of how these cases should work. And for that, I want to certainly raise some concerns and challenges, but I also want to try to conclude on a fairly positive note of maybe some of the ways in which these cases could be done in a way which is consistent with a proper economic framework. Yeah, it doesn't work very well, does it? There we go. So here's the framework. This is the legal framework. Mr. Pezzoli referred to this a few times. All of my talk is really going to be about application of excessive pricing under Article 102 and similar legislation in European member states. And this, of course, is the famous United Brands test. And on the face of it, it's got quite a structure there. So because it's Article 102, like any other Article 102 case, you start with market definition and dominance. Is the company dominant in a relevant market? And then you get into the bits which are United Brands, and this is where the excessive pricing tests come in. Mr. Pezzoli referred to the two stages. Here they are. The first one is the difference between costs and price excessive, and then secondly, is that difference unfair? And that unfairness test, the second limb of the United Brands test, sorry for the jargon, has two possible alternative components, whether the price is unfair in itself or in comparison to other products. The term competing products, but doesn't really mean products that are competing against the product under investigation. They mean products in competitive markets. So, all of that looks like quite a structure, quite a good structure, quite a complex structure, lots of, if you like, safeguards in there. But the concern would be that all of that structure really, in a sense, can get collapsed into a single sort of blobby question, which is just, are prices too damn high? And I think that there are examples from some recent cases where, in effect, that is happening, and that potentially has damaging effects on business confidence. Starting with dominance and relevant markets, well, this is a sort of tricky bit of economics, but one of the things that competition authorities sometimes say, and this is part of the market definition in the Venetoan case, is that if you can raise prices significantly above competitive levels, then you must be in a market by yourself, because we know that in those circumstances, if we observe that people are not switching to other products, that must be a separate market. And simply looking at the substitution that you get when the prices are high is the cellophane fallacy, and we all know to avoid that. And the trouble is that this sort of perspective ignores the fact that you can have a market price which is set by a high-cost product, or a market price that is set by a somehow inferior product, against other products which are certainly part of the same market, but actually have much lower costs, or actually have much better properties, and are therefore highly profitable. So you can be highly profitable in a competitive market and still have costs well below the market price. And the oil market is the classic example of this. I mean, I assume that people accept that there is no way that a low-cost oil field, such as the oil fields in the Middle East, is somehow excessively pricing and should price just at the level at which it produces oil when it is selling into a global market in which the price of oil is set by the marginal field, by the most expensive field which is actually producing. People will accept that, I think, about the oil market, but they don't seem to accept that when a company markets a drug which is pricing up to the price of its nearest competitor, which is more expensive, that can be accepted as being part of the same market. Instead, competition agencies will sometimes regard that as the cellophane fallacy in action and say, well, of course, you're pricing above your costs, that's pricing above the competitive price, so you must be in a market by yourself and you must be dominant. The problem with that reasoning is it's circular. Again, it gets back to this sort of question of the blob. The price is just too high, and it keeps coming back to that. And I want to be clear that in the CMA's case, the Pfizer-Flynn case, there were very good reasons for the market definition that they adopted. There were very good reasons for finding the company to be dominant, which was particular pharmaceutical characteristics of the product under investigation. But possibly prompted by lawyers, they also gave many other reasons for every single bit of the decision, and some of those other reasons are effectively the ones I'm criticising here. So that's market definition. Dominance. The main thing I want to say about dominance is around entry. I'm not going to talk about the Aspen case in Italy, but I will talk about something that happened after the Aspen case in Italy, because, as Mr. Pezzoli said, the Italian Competition Authority assessed whether entry was profitable and decided that it was not. And, well, you were wrong, because there has been entry. Generics have come into the Italian market competing against Aspen's products with identical generic substitutes for some of the products that the Italian Competition Authority investigated, obviously after the investigation concluded. Now, I mean, no shame in that. I think that one of the things that I've certainly found over the years, particularly from ex-post reviews of competition authority decisions, is that competition authorities are really bad at deciding when entry is likely and when it is not likely. It is one of those things where you're trying to second-guess the market, and I think we are not very good at that. And what this means is that it really brings home the importance of sticking to the idea that excessive pricing cases really should only be brought, not just when entry looks difficult and maybe not very profitable, but when there are really very serious, very high, persistent, maybe even insuperable barriers to entry. Otherwise, you're really trying to second-guess the market. Moving on to the United Brands test itself. First test, of course, is whether price is higher than cost, which sounds like it ought to be straightforward, but of course, you all know that it isn't. There are many, many reasons why assessing prices against costs is not straightforward, but one of them, perhaps one of the most important ones, is illustrated by this product I've got a picture of up there. That is what I'm sure is a very comfortable seat on an aeroplane. And further back in the same aeroplane, there are some very much less comfortable seats, sold at a much lower price. Suppose that you were to assess the profitability of this particular product, the business class seat. Well, one of the things you'll have to deal with is the fact that it is produced commonly with the cheaper seats at the back. A lot of the cost, building the plane, paying the pilot, paying for the fuel, all of the other stuff is entirely common between these two products, the business class seat and the economy seat. And how you allocate those costs between the two will probably determine whether or not you find this product to be excessively priced. It is perfectly possible, given one form of common cost allocation or another, to find that this product is excessively priced. But we assume that somehow there's something wrong with that. So what is wrong with that? What's wrong with that is that there really isn't a very clear rule on how one should allocate these costs. And at the very minimum, competition authorities need to consider a range of different approaches so that they do not condemn what is actually perfectly normal business behaviour, which is to put a high price on those things where you think you're facing a low elasticity of demand, to put a high price on those things that you can put a high price on, and to put a lower price on those things where the customers are more price sensitive. And that's perfectly normal. But when you start talking to competition authorities about it during excessive pricing cases, they say, yes, that's Ramsey pricing. That's this theoretical thing that economists do. And you're advancing a portfolio theory of pricing, which is also true, that you say that what you actually do as a company is you don't look at the margin on any particular product, you look to see whether the margins overall are at least paying for your fixed costs, and that's all that you do. And these arguments are routinely rejected by competition authorities. But the difficulty is that they are perfectly normal business. I mean, in my business, there are consulting. There are some jobs that are more profitable than others. This is true of all businesses. There are entire consulting firms, not like my consulting firm, who will come along and go into a business, and what they do is they construct a whale curve, which is supposed to show you where your most profitable products are to enable the company to focus its attention on those most profitable products. People talk about the 90-10 rule, right? You make 90% of your profit on 10% of your products. Well, what if a competition authority comes along, takes a slice through your business, looks at those 10% of your products? Those products will appear to be excessively priced. Moving on to the last stage of the United Brands test, limb 2, unfairness. Well, having criticised him earlier, I want to now enthusiastically agree with Mr. Pezzoli's take on this, which is that one thing you should not do if you want an answer to the question of what is economic value is ask an economist, or at least certainly not an economist from this century. It was something that 19th century economists were immensely interested in. It is not something that people focus on today, certainly not in the sense of any notion of inherent value. If there is a value that economists can more or less agree on, it is that value is set by the price in a reasonably competitive market, which means that we have a bit of the United Brands test that actually does accord very well with economic theory, which is looking at comparable products, competing products. If you want to know whether a price is excessive, the one thing that you can do that most economists will agree is a good thing to do is to look at the price of products that are similar in competitive markets, reasonably competitive markets, and see if it's more than that. But competition authorities often don't do that. I will skip this slide. They tend to look at the other limb, the other branch of this limb of the United Brands test, where the prices are unfair in themselves. And that, to my mind at least, doesn't seem to mean anything. So, just to conclude, I was asked in the first version of this presentation that I gave at OECD in December in the kind of closed session to try to make some positive statements about what an excessive pricing case should look like. Partly it's around avoiding many of the things that I've talked about here, and I won't repeat them. But then just at the end, I don't really have time within this talk, and it's maybe not part of the economics to talk about this in detail, but I say there focus on remedying a cause, not penalising effect. One of the things about the UK case, the phenytoin case, is that the CMA found that the parties in question had exploited a loophole in regulation. Having identified that, the government in the United Kingdom changed the law to eliminate that regulation, and that loophole in the regulation, and did so quite explicitly citing the CMA's decision. Now, to my mind, that seems like an excellent public policy intervention. The CMA made an investigation, found a loophole in the regulation, the government reacted, closed the loophole, job done. Whether prosecuting firms under Article 102 and fining them actually added anything to that, or instead, as I would argue, merely increased business uncertainty, I think is an entirely different question. So with that, I shall conclude, and thank you very much.
Thank you very much, John. And now Philip Marsden, the only other lawyer up here beside myself. So,
okay, I'm just waiting for the slides. So my enforcement experience on excessive pricing has been solely with pharmaceuticals. So some people may say that I've been on drugs for quite a while. Perhaps appropriately, one particular case that has been mentioned gave me a grave headache on appeal. That case is going to the UK Court of Appeal this July, so I shouldn't talk about that one, though I'd really like to. I've also worked on 3 other excessive pricing cases when I was at the CMA, but while I'm no longer at the authority, I don't feel it particularly wise, etc., etc. Currently, 80% of the work I do is for regulators who may well be bringing excessive pricing cases, so I'm not going to talk about cases, but I'm going to talk about essentials. All right? What is essential in this area? And one of the most essential elements of pharma work is molecules. And when I think of molecules, the first one that comes to mind is H2O. And H2O is water. And this allows me today to speak in code about cases. It's about something I love, which is rivers. And there are links with competition, believe it or not. I teach competition law in Bruges, and here is a photo I took of a nice stretch of water that I like to run by. I like to run in competitions, particularly along one pre-glacial tributary of the Rhine. And I've entered competitions to race the length of my daily commute between London and Oxford along the river. That was beautiful, but almost as painful and difficult as an experience as running an excessive pricing case. Besides running, sometimes I prefer to compete on the water itself, which is nicer because at least it involves sitting down. So what can we learn from this? Well, at the very shallowest levels, obviously competitions can happen next to rivers and they can happen on rivers, and rivalry happens on rivers. Indeed, the root of the word rivalry is from the word river. And if you think of a river's currents and other terms for competition, like concurrence or concurrenza, you can readily see that there are important links. So my water analogy to competition may not be that weird. With rivers, as with markets, there is an upstream and a downstream. And the direction of flow is important. And for anyone visiting Paris for the first time, here is a river-based hint about how to tell your left bank from your right. The water level in rivers is extremely important for competition. So whether the conditions are smooth or whether they're choppy, you get a sense of fair play and a need for level playing fields so that competitors can compete on their own merits. Now, sometimes governments do decide to alter the playing field, so to speak, to change the water level, to give incentives to develop new things, to reward innovation. Patents allow protection from the natural gravitational forces of competition. They act like a dam, and when a market is protected and has barriers around it, price can rise like water behind a dam. Now, after a while, patent protection ends, floodgates open, competition enters, and one expects gravity to exert its force, and water and prices to flow downwards. Change can be very sudden, like when generics initially enter a market, prices can fall off a cliff, like water in a waterfall. But this need not be sudden. After all, it can take time for these gravitational forces to operate, and falls in price may be in stages at the very least. But it usually happens relatively quickly. One expects prices to fall and fall down to a new competitive equilibrium. Sometimes there are delaying tactics by dominant firms. We all know of pay-for-delay tactics. And here governments have to act boldly to force that temporary dam down. And as the great poet Robert Frost said, there is something that does not like a wall, that wants it down. So sometimes government force is needed to get that price back to the competitive equilibrium. Now, even then, the equilibrium may take time to calm. Prices may be a bit unsettled and turbulent, and there may be the occasional peak or trough, but nothing extraordinary. And oddities can happen as well, and prices can go up and down while the market stabilizes, firms exit and enter, but these are just temporary adjustments. And spouts are always followed by gravitational drops and competitive prices. Now, sometimes the competitive waters aren't available and supply remains constrained through a narrow channel. In pharma, you would think of something called a narrow therapeutic index. And the delivery mechanism that this entails, this channel, keeps prices and flow, water flow, and competition constrained. And here, weird things can happen. Tiny cracks can appear in the legal regime, which can be exploited by suppliers, as we've heard, who drive prices up through the regulatory crack. Usually, the relevant regulators, say the National Department of Healthy Plumbing, can make a quick fix and plug a leak. But sometimes the flow, the sudden pressure of high prices can be too much for the plumbing regulator, and if so, it is natural that a responsible regulator turns to its competition authority for help. And we would certainly expect a regulator to ask for help if something extraordinary, something explosive, something excessive happens, like, say, if the water level went up about 1,600% or 2,400%. That's a price geyser. Yes, I pronounce it geyser, which rhymes with another word. Geyser, it's just water I'm talking about, right? In such a geyser, some pressure is forcing the water or the price sky high. Something completely contrary to the normal forces of gravity and competition is doing that, and regulation and the market are powerless to control it. And in some cases, we have seen not a geyser of a short, sharp, intense price geyser, but a tidal wave of long-lasting and even higher price increases, say 6,000% over a period of years, with no or little entry, and still oddly high and even scary price waves rolling through the economy. So, what is the Department of Healthy Plumbing supposed to do about these sorts of geysers or tsunami? Well, some people say that the plumber has incredible power. After all, it is the government. It can constrain the wave increase by legislating for new tools, and we've just heard that. But that's not always possible, and it's not always enough to constrain the flow of these kinds of massive geysers or waves. And no matter how powerful the government is, there are some tides it just can't stop, or at least a small unit of a decentralized government department with maybe a very small staff with conflicting demands and holes in its powers. They can't stop it. So this is particularly the case where there is a failure in the regulation itself, which has allowed a small loophole or gap. And through this gap, exploitative prices can shoot up, with the result that the customer, even if an arm of the government, ends up on the receiving end of a power it is supposed to control. And thus money that could go to other good works in the pharma sector, I think of nurses, they lose out because the money from the exploitative flood goes down the drain and into the deep pockets of the pharma company, supposedly for research and development. John said this, so I don't need to say it out loud, but there is not much a responsible regulator can do but complain that the prices are too damn high, and they go to the competition authority. After all, excessive pricing is an express infringement of competition law, and a finding of that can stop the conduct and, very importantly, pave the way for compensation so the regulator can get back some of the overcharge. So when should a competition authority help out? It has, after all, other fish to fry, frankly. And I can't think of many competition authorities who actually go out actively seeking excessive pricing cases, right? But clearly, when there is regulatory failure and the market has failed to correct the price increase through insuperable barriers to entry, then there is a case for action. Now, when a competition authority gets involved, it has to work out whether the price spike or the wave is excessive. And some say it can only do so by reference to comparators. But that only works if the comparator is in a situation of competitive equilibrium. Otherwise, you're looking just at weird peaks and weird troughs that are sui generis. So a competition authority can't say the price is excessive by comparison to situations where the water level is a lot lower, like below the competitive sea level, like the Dead Sea. Competition authorities don't look at those kinds of prices because their prices could be held down by regulation. But equally, it seems a bit rich for a dominant firm to say, don't worry about that little geyser. There's water way up higher in the mountains. And it is true that there can be water in the mountains. And that water is clearly supported by something, right? Usually some sort of regulatory structure or perhaps anti-competitive activity, and that's preventing the water from flowing downwards. So pockets of high prices are not a good comparator and not a good reason to say that the geyser is okay. Now, about comparators specifically, I do have something to say about that. I mentioned molecules before, and in some cases, water is essentially water, and chemically we would call that H2O. And that happens in pharma as well. Molecules are molecules. But like pharmaceutical molecules, it can come in many forms. And some forms, like capsules, are slow release to manage delivery gently and easily over a long term, usually with a life-threatening condition. Others, like tablets, are rather fast release. And there is a difference. All right? And even if the actual product has the same molecule, you cannot say they are comparable. Even if they are the same molecule, I have to stress that. Context matters, the patient's needs matter, delivery matters, the need of the patient in particular, as I say, matters and should be influential. So comparing one form of water with another in that kind of context just muddies the water, frankly, and doesn't provide clarity. Dominant firms with price geysers say they need these geysers to pay for R&D elsewhere. And competition law intervention would make that R&D dry up. They would have to withdraw from some markets, and patients will be harmed through lack of supply, or there will be less innovation. But no competition authority has ever said that a company has to make so little money that it needs to leave the market. So I view the threat of drought argument as particularly pernicious and arguably extortion. So when the CMA announced one of its interventions, the head of enforcement actually said on television that day, on the Fenatone case, that the CMA was not actually against a dominant firm making profits, and price increases of 20 or 30% or more might be reasonable, but 1,600% and 2,400% price geysers were naturally subject to correct investigation. So what should the price be? What's the best water level? No competition authority will ever say, and that's sad, frankly. I understand why they won't say it. We want competition to determine the right price. We want flowing rivers. We don't want beautiful Parisian pricing canals. That said, authorities should provide some guidance, not just keep trying, and if you get it right, we won't intervene. In the case of Pfizer and others, we did make directions on how Pfizer could amend its pricing based on costs, activities of the supplier, commercial risks, and any innovation, which of course there wasn't very much in that case. My final word is about judicial review. I'm all for higher courts and sermons from the Mount. I'm all for competition authorities having their decisions appealed to a specialist tribunal. I'm comfortable with the perspective from the mountaintop being a judicial review standard, like in the EU, of whether the authority has made a manifest error of assessment. I'm also comfortable-ish with the authority's decisions being reviewed through a full merits appeal. And I'm comfortable with remittals, being asked to do the work again. This is when the higher body sends the decision back to the authority to run the case again, in accordance with judicial guidance. What I'm not comfortable with is an Escher staircase of both a full merits appeal and a remittal with no guidance from the court. This is an endless looping water wheel with no remedy in sight while there's harm that's ongoing. If the court has the right to substitute its own decision under full merits appeal, then it should do so. And if it doesn't have the evidence base to do that, then it should remit the decision back down to the CMA or any other authority, but with really, really clear guidance on how the authority should make its decision. It isn't a proper function of its full merits appeal powers to say that the national authority didn't do its job properly. That's probably the worst thing a British person can say to another British person. You have to give guidance on what the proper decision is, or better substitute your own decision and do that properly. After all, if you've had a month-long appeal hearing with cross-examination and economic witnesses, make your own decision. Right? Or give at least some guidance to the national authority about how it should make its decision on a remittal. That would be proper. Saying go back and do your job properly without any guidance is an abysmal failure of power of the judiciary of full merits review, particularly if that tribunal decided not to follow firm European precedent, instead just the statements of an AG. That's not particularly proper as well, and I have deep respect for AG Wall and largely agree with him, but that's not European law in this area. So some headaches in excessive pricing cases, but there are some bright sides. Authorities don't go looking for these cases. They don't. They take them only in extremis when there has been clear regulatory failure and there are insuperable barriers to entry. So there is no government remedy and there is no market remedy, and thus a competition remedy is needed. Now, I started by saying that I may not love these pharma cases, but I quite like rivers, and I quite like competitive pricing, not excessive pricing. There's another reason to be concerned about excessive pricing, because it's not just about a dominant firm exploiting a healthcare system and reaping monopoly profits through price geysers. It's also the opportunity cost of what it is draining from the healthcare system by charging medical authorities so much. And that is the fact that these funds would normally go to other good works of the healthcare system, like more staff and better equipment. So in thinking about these cases and the swotty stuff about competition law and economic value, think about who is harmed by this: healthcare and self and care review. Thank you very much.
Thank you very much for this and for forcing me throughout the rest of my life to try to present an allegory in rhyme. I was hoping to have a discussion here, but we only have about 10 minutes left, so I would rather leave it to the audience to ask questions. Yes? The microphone's coming.
Alberto Pera. I have a question which comes from the presentation from Valérie Paris and Andrea Pezzoli, relates to the Aspen case and particularly the issue of fairness, which poses in the last part of the cycle, which Valérie explained. So I wonder how important it is that in the Aspen case, Aspen was not actually the one who discovered the principle. It was the one who acquired the license from another producer, and it acquired the license not only in Italy but in other countries as well, just to the end of increasing the price. So basically a little bit like the patent trolls. It was purchasing the right of exploiting. So this obviously a little bit qualifies the fairness point, which is the last point in the evaluation of excessive pricing. And obviously qualifies very much this kind of procedure as a very exceptional case.
Alberto, I think that this is one of the main specific features of the case. I mean, it was simpler than we expected just because of the characteristics of Aspen's strategy, which was just a mere arbitrage. It was nothing similar to an innovative effort or a company who invested in R&D expenditure. So, I mean, given that there were no justification for, let's say, innovation investments or innovation efforts, this specific strategy adopted by Aspen was one of the reasons why we could consider the prices not only excessive, but also unfair. I can also add that since that was a pan-European strategy, this is one of the reasons why, and this perspective I partially disagree with John Davies, that in this specific case we couldn't use the most, let's say, the soundest approach for benchmarking, which is the benchmarking with the same products in other markets. I mean, being a pan-European strategy, that comparison would have been meaningless.
Yes, Fred Abbott, law professor and consultant. Well, it's a very complex subject overall. I'm a bit disappointed we didn't discuss originator pricing today, but that's a more complex subject at some point in the future. When I heard Mr. Davies begin his presentation, I was initially quite disappointed to think that maybe the OECD competition group had gone out and found one of the 2 or 3 human beings on the planet Earth who might attempt to justify Pfizer's really shocking conduct in the phenytoin case and somehow justify that by referring to competing products versus unfair in itself as being the appropriate test. And I really just stood to congratulate Professor Marsden because he took apart Mr. Davies and his presentation in a way far better than I might have, although I did publish a piece on this in IIC explaining the defects in the reasoning of the Competition Appellate Tribunal, which, as Mr. Marsden noted, relied on Advocate General Wall's position on relying on Justice Scalia and the Chicago School and sanity checks versus the appropriate application of ECJ or CJEU jurisprudence, which was then relied on by the Competition Appellate Tribunal for no apparent reason, simply decided that it would ignore United Brands and the jurisprudence of the CJEU, which in fact had relaxed the standards for excessive pricing in the Latvian copyright case, which was exactly the case that Advocate General Wall had been relying on. So the net point of my comment is simply to congratulate Professor Marsden and to point out to the group, I think, which I hope you recognize, just how important this decision in the phenytoin case is for the future of affordable access to medicines. And again, at the end, you pointed out how difficult it is to actually understand what is going on right now, because people ask me, well, what is the status of the case? And you look at the CMA website and it says, well, it's been remitted, but we're appealing, and we've got this judgment that says, well, they didn't explain it. We don't know what they might have explained, but they should go back and do whatever it is that they didn't do, that we don't know what they might have done, but we'd like them to do it. So it's really just a most curious development, and I don't know what got into the heads of the Competition Appellate Tribunal. Thank you.
Thank you. I'll give people the opportunity to comment. I would just appreciate it if people kept the comments to mainly questions and kept them short, because everyone traveled. We invited our guests to come here and present for you. John, do you want to say anything?
Look, I mean, you obviously feel very strongly about that. I can understand that. Was I defending Pfizer's decision? I'm not sure that I was. I was talking about the framework within which we assess these things. There is a framework. There's a legal framework. The legal framework looks at certain economic aspects. Companies under investigation have a right to make their defence and to rely upon certain sources of evidence. And competition authorities need to justify their decisions properly. As I said at several points during my presentation, I actually think that a lot of what was done in the CMA's phenytoin case was absolutely right. And in particular, I don't for a second dispute where they ended up on market definition and dominance, for example. My point is that we do have a framework, we do have a system, we do have ways of trying to bring evidence into an investigation, and simply to look at something and say it's outrageous and too damn high is not enough. We have an economy which depends upon businesses knowing how they will be investigated and how they can bring their defences against those investigations and what they should do in those circumstances, and we have courts that decide upon that. And I don't see anything wrong with any of that system, and I don't see that one side should necessarily always be given the benefit of the doubt over the other.
No? Do you want to?
Yeah, so it's, all I'd say is, this is not really a response to John directly, but it would have been a very easy decision and very short decision if we just said the prices are too damn high. Instead it was sort of 600-page decision, scores of pages on comparators. We did not, in the words of the Competition Appeal Tribunal, simply ignore comparator evidence. We looked at the credible evidence before us, a very long-running investigation. Yes, all manner of interesting things that we put into the decision that sort of tried to help explain what we thought was going on. And people may, say that there was too much of that in there or whatever, and they probably will. But the point is that we were trying to show the context of this conduct. And of course, extraordinarily aware that we're not asking for the floodgates to open on this issue. To go to the fairness point that's sometimes hinted at in conferences, these excessive pricing cases are not a populist wave. They're not to do with fairness, okay, in terms of how they are initiated. They come because there's been regulatory failure and a market gap as well, and that there's an infringement allegation. A complaint comes from a consumer group or from a health body that says, we need your help, Competition Authority, and by the way, it's 102A. Right? And that's been in the treaty since the 50s. And so it's not a situation where I believe they're coming from some sort of populist or fairness wave. So therefore, I would encourage people not to try to write fairness interpretations into the actual analysis, other than where it already is, right? Which is already there in the case law as well. So it's a very difficult area. I've talked about insuperable barriers to entry. I've talked about regulatory failure. I've talked about the need for some sort of ability of a competition authority to help plug a gap. But do not forget that you need to get the compensation. It's not enough just to close the hole 4 or 5 years later. That is a nice solution, and in fact, actually, that would be the preferable solution initially and a lot quicker. But there's a triangle of harm, significant harm, and we want it back, and we want it back into the health authorities and give it to the nurses.
So in order not to delay the next session, I would just like to thank our speakers today, and I would ask you to thank them in your behalf as well. Thank you very much.